10, approval of Tapestry Public Charter School Incorporated. Can I get a motion? Moved by Mr. Orson, second by Dr. Irwin. Is there any discussion?
Dr. Johnson.
Dr. Carter?
I just had a few questions. I understand the purpose and the process, and I'm in 100% support of having a charter school that has a focus and an emphasis like Tapestry. One of my concerns, and it's not just for Tapestry, but it's overarching, as we have talked about programs and services that this district provides and being responsible stewards for our funds. Do we have something in place? Do we have either policy in place or practice in place that needs to be adopted into policy to ensure that, one, we can cap enrollment? Oh, that's when we talk a little closer. Thank you. That we can cap enrollment, or that we have some way of defining what the per pupil cost is to the system. When we say yes to a charter school, we need to know what we're saying yes to in terms of dollars and expenses, both for per pupil. And I didn't have a sense that there's a cap. I know that it's scheduled to be 96 students for the first year and then adding on each year thereafter. But is there a way for us to address that?
Mr. Superintendent,
Okay.
I've asked Mr. Superintendent if he would respond to that.
Well, no, I'd ask Dr. Bell, could you come to the microphone, please? It's a very pertinent question you just raised, Dr. Carter. And could you respond, Dr. Bell, because this is an ongoing discussion we're having regarding the costs associated, the allotment, first of all, in terms of FTE and student count, as well as the cost to provide some of the auxiliary services that might be needed within not just Tapestry, but any charter school.
Yes, sir. Mr. Superintendent, one of the things we've recently determined is in relation to the funds that the charter schools get monthly allocated. There has been statements made in the petitions that the Board of Ed has approved about allocations, a number of students in first, second, and third year, okay? And some charter schools that have grown their enrollments above those stated numbers in the petition have received allocations at the higher number, even though it's above what's in the petition. Recently, working with Mr. Ramsey, we've determined that what has happened is, even though the BOE would vote on a petition, that the state has incorporated into a 4-page document statements that sort of say the petition is the application, but what's in the charter that the state approves is really the guts of the agreement. And oftentimes in that agreement there won't be any cap on enrollment. So if you're concerned about the 96 first year enrollment statement that came up this afternoon, I think if you do pass this, you probably need to make it a condition that that number of 96 or 110 or whatever you deem reasonable is being approved and should be put into the negotiated document that the state is going to send to us as we go forward.
Mr. Bell, just one other question then. In addition to attending to the number of students, what about the other ancillary costs that are associated with supporting services, transportation, our cost and expenses in terms of the work that we do back in the district to support those systems? How do we cost that out, and how do we recapture those expenses?
Well, for items like transportation, that's a separate negotiation. Mr. Wilkins can tell you how much that costs and what we would recover. The law right now says we do get to retain 3% admin fee, which we do in all charter school cases, okay, for the other general services that we provide. However, it's been stated the state charter school division or department is saying that we don't give them enough autonomy and we need to pull back in some of the services that we have been providing, and we've indicated that to the charter schools at meetings with them. But we do retain the 3% right now.
Got a question?
Mr. Campbell.
On the 3% that you're speaking of, have we measured that to know that it fully recovers our costs? Because I think what Dr. Carter is saying is, it seems to me that we're just arbitrarily picking a number, 3% may be it.
What's in the
But
law?
It's a state law, so that's the max that we can do.
We don't have
Yeah.
Okay, thank you.
Mr. Coleman?
So those folks who were here for the earlier session know that I had a number of questions. One of the questions that was answered during the course of time, I had asked essentially, in the current charter, the lottery is for a general pool of students, and I thought this was worth clarifying for folks who were engaged earlier. There was no criteria for a number of seats saved for students on the autistic spectrum versus neurotypical students, given that it's a mixed population. I've been informed that there are legal barriers to having any number of seats reserved. So that concern of mine was fully addressed. And, I asked a lot of questions earlier. The comment I would have is obviously it's really encouraging to see a group of parents, a community, a group of staff members come together to support students in our district with special needs like this. And so thank you to all the folks who are working on this for putting together a very thoughtful proposal and thinking about this group, because I think it's very important that we pay attention, especially to students within our district who have different needs than other students. So despite all my questions earlier, which were just geared towards making sure that we're doing the right thing here and that this is set up, I just want to thank all the community members who worked on this, because I know this was no small task.
Mr. Orson and Dr. Morley.
Yeah, I do. I want to iterate what Mr. Coleman said and also add my congratulations. There has been great and very hard work done on this, and I've had the opportunity to meet with some of the organizers over the past 6 months. This is a population that is underserved by us and other school districts, not by design, but because our middle schools and high schools really aren't designed to accommodate students in a number of categories. And yet it's also coupled with an inclusive model that we have seen the success of in our own school system, like Coralwood, and outside agencies like the Fraser Center. And so there's a lot of examples of success. And I think the opportunity to try to translate that success into delivery of services to 6th, ultimately to 12th graders is a great thing, first and foremost, for those children, but also can help define us, again, as a leader and an innovator in education. That it doesn't have to be everything that we do in the central office in our traditional schools, but that we are prepared to embrace innovative ideas to ensure that every child does have an opportunity for a great education. And so I think we need to keep that in mind, and I think they have done the work that is deserving of our support and approval.
Dr. Morley.
I won't rehash my statements and concerns earlier today. Well, certainly I agree with any program that's going to be for the benefit of our children, the education of our children, the education, academic success and excellence. As Dr. Carter was stating, and I stated earlier today in looking at the CAP, and we talked about the word guarantee or assurances. Nothing is assured unless you actually have it in writing from the onset and have it in a contract to be able to say that those limits will not be exceeded. The other concerns I had, again, is the fact that if we're talking about, when I was presented this program some months back, it was dealing with special education students, and I thought it was a great idea. But now I see that it has broadened, that it's all students, inclusive, gifted, and otherwise. And I'm just concerned about the veracity of what it would take in order to be able to meet the needs, and also the training and the education of the people who are supposedly going to be in the program to be able to meet those needs. When we're talking about students with neurological deficits and also students who are autistic, even with a 16:2 ratio, to me that seems a little high. I have some concerns about it. Most certainly I would not, nothing can diminish the hard work that was put into putting this proposal together, but at the same time I believe that more work needs to be done. I believe that as a board we owe it to every citizen in this county to make sure that when we approve something, that we make sure that we're approving it for the long haul and not for the short haul, and that we know that once it's approved, you can't go back and undo. And as I said earlier, the way you start a relationship is the way it will end, and we need to make sure that this relationship is started on the right foot.
Mr. Mayfield.
Yeah, and I guess my only question would be, and this relates to the academic performance of autistic children and the relative size of the population of autistic students in the school. I'm wondering if we have an opportunity to have that as a part of our criteria for reevaluation. In other words, if the year 2, as an example, if there is a number that is significantly less than 50% of the students, and if those students have not performed at 3% above the performance of the students in the prior year, that both of those would be part of our evaluation process and determine whether or not we renew the charter.
Mr. Thurman?
To Mr. Mayfield's point, and one thing we can do and must do, now that we are into the strategic planning process, we have to look at how we approve charters going forward and how we evaluate them. And to be honest with you, many of the policies that Dr. Carter mentioned do not exist at this point. But what we have the opportunity now is to recalibrate going forward and to engage in the proper due diligence. And this probably doesn't even impact Tapestry, but there will be others. And so going forward, we'll have now a broader vision and a strategy and a process and a procedure to look at how charters or any other institutions or innovations will impact not just today, but the long-term viability of the DeKalb County School District. This one was already in process, so I understand that these ladies have worked hard on this. But there's the bigger issue that I think Dr. Morley is referring to, is that what then is the impact district-wide? And right now, we really just don't have the capability or the understanding to offer you an objective analysis of that. That's the way it is today, but it cannot be this way going forward. It just can't. And it's not fair to ask you all to make these isolated decisions based on, because, all of them sound good, but you got to, okay, what is the broader impact? I'm not talking about Tapestry. I'm talking impact to the budget, because if it negatively impacts other students, then you have to weigh that opposed to the positive impact of these students, because we are here representing all students. But right now, I can't say that Tapestry will do that because we just don't have the internal capability to make that decision right now.
Dr. Morley?
One last statement. I just don't think it's fair to Tapestry.
No,
And if we allow one, and as we said, it's across the board, because I most certainly believe in anything that's going to be the excellence enhancement of the education of our children. But we start setting precedents, and either we stand for something or we'll fall for anything. And we have to begin to actually give people direction. That's what we're here for. If they don't have it right this time, what can we do to help them to be able to get it right? And so if we start accepting it and saying they can do it, then what happens to somebody else who comes along and say, hey, you all did it before, so why can't you do it now? How can we be exclusive, or we don't include everybody when the time comes around? And it is a broader picture. And I think we have to begin to look at not just what's here now. We are in the here and now, but what's in the future? How is it? What's the impact? Economically, socially, we have to begin to look at all those things that are coming to bear. And if we don't take a stand and look at it now, when are we going to do it? How many times are we going to go back and say, well, we'll just let this go through, and we never take what we're here fundamentally to do, that's to govern what's going on in this system and making the proper decisions for the education of all children from north, south, east, and west in the DeKalb County system.
Mr. Orson?
Dr. Morley and Mr. Thurman, I appreciate those comments. And we are in an interesting position because we are responsible to the school system, but we are also responsible to uphold the law of Georgia. And the law of Georgia, whether we agree with it or not, sets the standards for the creation of charter schools. We are not allowed by law to substitute our judgment of that law, even if we think the law is flawed. The law sets the standards for us, and we have to be careful. I mean, we could get 100 charter applications. I don't think we will, because it takes, as we've seen, an enormous amount of work to do these things with people who are dedicated and committed and who are on the hook for the success, because if they don't do it, the charter goes away. That's the ultimate sanction we have as a Board of Education. But I have to caution, and I think all of us, because in any individual case we may react that that's not an idea we like or we approve of, but we are duty-bound by our oath of office that we all took to uphold the law of Georgia. And the law of Georgia establishes charter schools and the conditions for the creation of that charter school. And we have to be mindful, regardless of whether we think in some general or broad fashion of trying to analyze it about, well, where will this lead and what's the impact of it. The state of Georgia, the Constitution and laws of Georgia tell us the direction and the factors in which we can make these decisions.
But the state of law also tells us that it is incumbent upon each board member to make a decision based on the best interests of the boys and girls of this entire county, and that is included all the students rather than a selected few of the students. So we just want to keep that in mind.
Well,
Dr. Marley.
Dr. Johnson, can I respond to this since you were responding to my comment? I don't disagree as a philosophical premise. I mean, I understand that sounds, and I agree generally that we are looking out, and I think we are always looking out for the children of this county. But I do not think we can loosely interpret that there are standards, whether we agree with them or not. Let's put it in the standard that dictates, because we have seen the consequences of that. This is a game, how it plays out, the consequence of certain decisions ended up with an amendment to the Constitution, regardless of where one felt. I mean, we don't have the latitude. Well, we have to look out for the children of our school system. I absolutely agree with that. It is a very delicate balancing out, because we do not have the latitude to undermine the laws that do apply to us, regardless of what we think. And so it's a very difficult. It's an art, not a science. I understand that in there, but I think we just have to be mindful of what our duties are, as established by the law, in terms of considering these in application.
Mr. Chairman, of course, lawyers interpret law based on their understanding as to what that law does dictate. And only the Supreme Court of the state of Georgia will make an ultimate decision. The rest of us are offering opinions as to what we believe that it states. And we all have opinions.
Absolutely.
And I want to say that most certainly is greater than judgment. And then why are we here? If we can't make an informed and the right decision, why do we take these positions? To be on a board that's to govern and to make the right choices. And if something is half done, we wouldn't eat a half-baked cake, so why are we going to have something that's half done? It is not fair to Tapestry if they don't have all the full information to be able to put this program together. And one of the things I'm concerned about, and we can go down that path that others have gone before, is that we keep rushing to decisions instead of taking it and taking a thorough look at it and looking at the impact. We must look at tomorrow. We can't make decisions with millions of dollars and hundreds of thousands of dollars based on where we are right now and not think about what's going to happen in the future. We must begin to look at what's the overall impact. And we can look at legalities. I might not be an attorney, but I'm an educator. I've been an educator for almost 30 years. And so I know impact. I know how it's going to affect. And I've seen programs come and go. And one of the things that, as an educator, and most educators will tell you, we've seen too many programs come in. Our children are not guinea pigs. They're not here to be tried, tested, to see whether it's true or not. If we take our time, I've had 2 children come through the DeKalb County school system, and I remember fighting also for an AP, a student, and they are tracked. If anyone says that they're not tracked, that's not true. For my student who was AP, because they couldn't find a teacher to put in a regular ed class. So we need to make sure there are parents out here looking and wanting to make sure that they have a full understanding. And one of the things that we look at the program, the Bridge program, and some of the things that we're trying to do is to help educate parents on what they need to know. All of the parents have not been educated. There are laws in the state, but unless somebody stands at some point, and this board be one of the first maybe to stand up and say, let's question some of this stuff. How can we make sure that we are not taking money, good money, and throwing it after bad? How many of these schools are actually successful? Let's give these people an opportunity to get it right so that when they don't come back later, and then what do? Come back again, and then we are going in trying. It's better to prevent than to intervene. It's harder to intervene and fix a situation after it has gone corrupt. I just see that there are too many variables, and it has nothing to do with judgment. It has to do with truth and facts that are there. And we can look and see that there are more of these charter schools, and it has nothing to do with Tapestry. But charter schools across the board, they come in and agree to one thing, and then when they decide to, they go above and beyond the number of enrolled students, and then the system is required to make that up. That is not fair to those parents who didn't have a choice as to whether their child could be there too, and you're pulling money away from those parents and the taxpayers. And then if they don't have an informed process to make sure that they actually agreed with that, then you're going to tell me that's judgment? No, that's facts. And it is facts on paper that this has taken place. And it's time for someone to address it. Either we do or it won't be addressed at all. Then what's the purpose of having a board?
Mr. Coleman?
I'll be very brief. I think this is a wonderful debate, actually, and I'm glad we're having this charter debate now, and that I'm sure we'll continue to have it over the next month or two, as we saw from the earlier citizen comment section, which I thought was actually one of the best citizen comment sections we've had so far. It was a very engaging debate between very well-informed parties. I think the important thing to remember tonight for me is that while this broader debate is incredibly important, and it's one that we should be having, the decision before us is really just Tapestry this evening. And so I just want to make sure that we make our decisions on that based on the benefits of this particular institution, and that, you know, it's informed by that broader debate. But this is really a vote on this particular institution, not the broader debate, and us deciding whether this is in the public interest. And you know, I think a lot of hard work went into that, and for me, that's an important thing, just to evaluate this particular proposal this evening.
Do we have additional questions or concerns?
I just have one other question.
Yes.
I understand that we have to take this proposal as presented. However, with regard to the negotiation of the contract, should this be approved, what are our legal limitations?
Let me ask the legal, since we have a deadline to deal with in terms of the number of days, what are the options here? All right, we can approve it. We could not approve it. If we did not approve it, what would be the next step? Could they go back and come back at another time?
Yeah, so the options are sort of what you just laid out. You can approve it or you can not approve it. If you do not approve it, then under the statute, you have a period of time, I think it's 60 days, to set forth in writing the reasons why you did not approve it. And it needs to list out why you know, whatever it is that they didn't do. I think at that point, it's they have their own options to consider. They can decide to go to the state directly. They can come back and try to correct some of the stuff that you've identified as not, that you weren't satisfied with or whatever. But that's really up to them how they choose to proceed. I'm not sure I totally followed the first question you had.
If we choose to approve this, what is the latitude within the contract negotiation? Again, do we have the latitude within the contract negotiation to say that we expect them not to exceed the number of students that they're proposing be enrolled on an annual basis? Not the complexity, not the composition within that number, but the number as a whole.
Yes. Let me just say that we would then negotiate with the State Department of Education. We are aware in the past that they have allowed districts, including DeKalb, to put in a provision in the contract that would limit enrollment. I don't know, I'm not sure it says 96, and if you go to 97, but I mean, it would have a limit that would make it where you couldn't have a significant difference from what they've represented. And we would negotiate that with the state, as well as other provisions to try to get as much of the charter language, the representations that they've made, into the actual contract. But again, that's a matter of negotiation.
And what? I'm sorry.
Mr. Thurman, I'm sorry. Go right ahead.
Oh,
I'm sorry.
Mayfield. Just because both of us are short.
Mr. Mayfield. Mr. Mayfield.
My question is about process. Do we know how long, if we were by chance to not approve, and we went through the reconciliation process, I guess, for lack of a better term, how long is that time frame, and what time window would we be looking at?
Well, again, I think you have 60 days to respond, and that nothing precludes you from doing it immediately if you're trying to, speed it up. But
right, and then they would, if after that 60 days, just playing best case scenario, how much time would they have to submit to the state? And how long is that process?
Again, that part I'm not as familiar with, so I'd have to go back and check that. But that would be a choice they would have to make, whether they wanted to go that route or try to come back and fix things here.
Okay, yeah, and I guess the only point that I wanted to just sort of illuminate is that when we look at our options for a relationship with Tapestry and the time that would be associated with reconsidering or evaluating their performance that might speak to some of our concerns, if that window is not significantly long, if the window for having this reconsidered at another level or in some other venue, then it may just be as easy in terms of time for us to use our evaluation process to determine whether or not they go forward in the 5 years, rather than giving them the option of looking at another pathway to getting it where we would have essentially little.
That question brings up another question in terms of that. If it is stated in the petition itself, whatever it is, the stipulations, then it does it give us any options to address the concerns that Mr. Mayfield has?
Are you talking about on an immediate basis, or when it comes time again to evaluate whether
Well, see, in terms of correcting, that would be 5 years from now.
Right.
Right.
So
to the extent it doesn't get into the contract itself.
Right. And that would be a concern. If it's the concern of the board to address and correct selected items in the petition itself, it appears that we should use some format to correct it before it leaves here. It's not that what I'm hearing, we're not saying that the board wants to deny the petition. What I'm hearing is that we have some concerns and we're restricted by time in terms of whether or not we can make those changes.
Point of information, though, because I think to connect your 2 points, the concerns seem to be, particularly if I'm correct about this enrollment number, which is a byproduct of the negotiation with the state, which can't take place if we don't approve the charter. So we can't get to the point that you want to negotiate unless we approve the charter. So if we don't approve the charter, there's no negotiation over the number because the state holds that decision.
But that raises the question in terms of Mr. Orson's comment. But if it's in the charter, then it wouldn't be an issue with the state, because it would be stated in the charter specifically what you want. Then it wouldn't be an issue with the state or anyone else.
I think the state has taken a different view on that. I mean, they have basically said...
So are you saying that if the petitioners made a statement in terms of the petition, what they desire, are you saying the state is going to change that?
I'm not saying they were going to change it, but what they won't let us do is to say we're allowed to hold them to every statement in the petition itself as if it were in the contract. And so they'll let certain things become part of the contract, but not everything. And if it's not part of the contract, then you're not going to have any recourse to deal with it on an immediate basis if they're not complying with the contract. You would be able to, when it comes time for renewal, to go back to the original petition and
But that's 5 years from now. The concern right now is the board, they have concerns relative to the concerns now.
Mr. Chairman, the interpretation provided by council would almost encourage boards not to adopt any charters, if that is in fact accurate, because what you're saying is that the board then or the district would have no or very little influence or potentially over what actually is included in the contract itself. So to me, that's counterproductive, because what board under those circumstances would commit to such an open-ended?
Well, and let me say 2 things. First is just because you approve this today, the contract that would eventually be negotiated will come back to you, okay? And you would have a second chance to either approve the contract or not. So that's A. So you would be able to review whatever's in the final contract and decide whether or not, well, look, this just doesn't cut it. I'm not comfortable with this. That's A. B, the most of the concerns that I've heard raised here, at least in my opinion, seem to be more generally broad-based, sort of bigger policy issues, rather than anybody pointing out a specific thing in the actual petition that somehow doesn't meet muster. Now, that doesn't mean that you can't vote against it. I think the statute does provide that it's your decision as a board member to decide whether or not you think this petition complies with the law and is in the public interest. And that's that language, and the public interest is in the statute. So if you don't think it's in the public interest to approve this, you have you're legally able to vote against it. But again, I think the concerns I've heard have been more general things about whether or not charter schools are a good idea or a bad idea, rather than I've heard something other than the enrollment question with something specifically in there that's troubling and needs to be fixed.
Counselor, one of the things I suggested earlier, but, I think that may not be what the petitioners wanted. What I suggested was that any specific concerns should be directed to myself so that we could negotiate with the petitioners and address them. And then we could then hopefully at some point go to the state with everybody on the same page. And I think was what Dr. Johnson was saying, then it would be a petition supported 100% by the district and the petitioners. The challenge we have right now, the questions, whatever they are, cannot be vetted. And what I'm hearing, and I don't presuppose how anyone will vote, so we're looking at either denying the petition or somehow creating an opportunity for us to work with the petitioners so that hopefully we could work collaboratively together to get it passed. And I don't know how anyone is going to vote, but that's what I'm hearing. That's what I tried to convey. I believe that once we clearly state what the concerns are, that we could work with the petitioners to resolve the issues. I do, but it's just a matter that will take some time. It'll take a day, it'll take 2 days, but it won't happen tonight, which is the problem.
So in essence, if a board member felt that the only way I could get my issue at least debated or resolved through the superintendent, well, the only thing that I can do is vote against it then, which in reality I might not want to vote against it. I just want my concern resolved.
No, understood. I think the issue is, and they are here, the time has run. We're under a deadline, and so the only way we can get additional time is if they're willing to request it. And I've been told, at least before that we've started this debate, that they were not willing to do that because they have their own timeline pressures.
He's discussing
and he may be discussing with that now. Anyway.
Meantime, who was first, Mr.?
I'll just take a
Mr.
quick
McMahon.
second. So we're talking about accountability here regarding the petition. It states clearly that I see the class size of 16 kids. Initially, the first year is 96 enrollment, 6 classes of 16 kids. If you go above that number, you're in violation because you have more than your ratio of 16 kids. The maximum amount of students in this over the next 5 years is 224 children, which is a total of 14 classes. You keep the same ratios. So we're talking about accountability here. So, and my perception is from being an accountable board, it's our opportunity to hold the state accountable and I understand our concerns to where we have an aligned focus with our petitioners, for ourselves, go forward, and the state says, you know what, do what you want to do. We approve it and take all the limitations off. That's not right. That is not right at all. But that gives us the opportunity to have the discussion with the state to say, that's not right. We are in collaboration with our community and our stakeholders for an effective learning model. We're together on the same page here. We're supporting each other. We're listening to our stakeholders. So I see accountability personally. Everyone here is concerned about the lack of accountability with the state. I think this is a wonderful opportunity to potentially have that discussion with the state, because we do realize that this is a large topic for future discussion in the whole charter school movement, which I think most board members here are for accountability in the classroom to the boardroom and to our legislature. So and my perception is I think it's a defined ratio classroom size to pupil to teacher. The numbers are based on their ratios, even though it may be high a little bit, instead of 8, classroom size. So I feel comfortable with the 96. Thank you.
We are running into a deadline here, and part of the problem is, I think some of the sentiments about the class, the enrollment size, they agree with, but we can't fix it, put it into a contract until the state agrees. The problem is if we don't approve tonight, I think there's a real risk we're running out the clock on their ability to get this school up and running on the timetable they said, because they still have to go from here to the state. There's a period that the state has. So if we delay this, it delays the state approval. Then it has to come back to us. So some of the issues that we've expressed some concern about, whether they appear in the contract or not, there's still time. And so for them to get the school up and running, I think there's great risk. And I think we also have to acknowledge some culpability without saying there's fault. They turned this petition in May. It's September. And so while we may not have had the benefit of having it before us, the district has had it before for almost over 3 months. And so the time period has run out with we're going to ascribe fault to the petitioners who dutifully abided by the timetables that we established, only to have us as a board now saying after the deadline has actually run out, well, we're not sure we're going to approve.
Mr. Coleman.
I have 3 quick points, I think. One is, I think again, I hate to be the person to reiterate this, I think we need to have specific objections to why this is not in the public interest if we're going to vote against this. Because I think, we do have a duty to not make this a macro debate about charter schools, but rather to evaluate the merits of this petition. I think, secondly, because we have a chance to review the final contract, they have outlined that the number of students that they're going to have next year is 96, and they've outlined the number of students subsequent to that. I think what we've heard is unless that is taken out or revised out of the contract, that would be our go-forward assumption for what's in it, and that we'll have final approval of the contract. That is the only specific concern that I'm hearing right now, is the class size concern that this could grow out of control. And I do think we'll have an opportunity to approve the final contract that comes back from the state. The third thing I would just highlight, and I think we've underplayed this a bit, and we probably haven't heard this perspective enough, is just the superintendent and staff recommended that this go forward. And I think that it was their judgment from May to now that this was in the public interest. I think so far, if the only outstanding concern we have is class size, and we have some, specific concern that we have is class size. So
I think
I would just like to hear from, if there's anything else to be said, I'd love to hear from the staff about why they felt this was a petition that we should approve, because that was the recommendation that came to us.
To resolve it tonight, I think maybe I should hear from Mr. Thurman.
No, go ahead.
Okay. According to the petitioners, they're willing to have it tabled for tonight and resolve all the questions or concerns that the board may have through Mr. Thurman, and really represent it in October. Did I interpret that? Okay.
Or sooner,
if possible, yeah.
And one thing, Mr. Chair, members of the board, I rely a great deal on Ms. Pat Copeland, who leads the charter evaluations. And I will say that Ms. Copeland has been very positive about Tapestry. However, we don't have the vote. And it's up to the board to decide whether to accept or deny the charter. And I think in the best interest of these ladies, everyone has worked hard. Whatever the questions are, if you will provide them to the administration, give us time to work with the petitioner and see if we can negotiate or address the issues raised by Dr. Marley and others, and then bring the petition back in October, hopefully. And we've worked very closely together, so I don't think there's anything raised that cannot be negotiated and addressed, and then we can resubmit or offer the petition for consideration by the board. And I have had a sidebar conversation with the petitioner. We feel like it's something that we can work out and get done, and at the end of the day, address the challenges or the questions that have been raised are very legitimate. And there's no question, no one can deny that. And at the same time, hopefully create a resource or enhance a resource that exists in the district for young people with disabilities.
Dr. Irwin.
So I just have one question. So when you receive the petition in May, is it, or can it be in the future that when you get the petition, we get the petition? That we all can be reading it at the same time? Because it kind of runs into a brick wall when we get here at the last minute trying to make a decision, and it's been here for 3 months. And some of these questions could have been routed out a long time ago. So is it possible to get this way in advance?
In fairness, I think a lot of what happens initially is when the petition's received and the administration evaluates the petition, and it sees issues right away. And so then they already go back to the petitioners and say, okay, here's some issues we're seeing, and they start negotiating. I don't know exactly what happened here with this situation, but that's why I think they may need some time to work out issues before they give it to the board.
And not necessarily with Stardust, but say, for instance, even with the charter cluster petition, there are processes that expect a period of negotiation and change. That the law, and I always rely on Mr. Arson, he's my chief constitutional lawyer, but the law basically presupposes that petitions will be renegotiated and changed in an ongoing, continuous manner. So oftentimes the original petition does not look in a great deal like the one that is actually voted upon. And secondly, to Dr. Marley's point, this is uncharted territory, no pun intended. Charters are relatively new. It's a new animal, and there's not a great deal of research or history in DeKalb or across the country. Obviously, there are those who believe in them strongly, and there are many questions by others. And so we are kind of working through the darkness, and which is why I pointed out that in the strategic planning process is where we need to develop the capacity to not just vote up or down, but to evaluate petitions and or the performance or underperformance of charters that we have, and what we're going to do about it if there are underperforming charters.
And I totally understand.
And that's going forward. We just don't have it now. And I hate to admit it, but the capacity it just doesn't exist today in DeKalb to do what we due diligence.
Since we have, I'm sorry.
I can understand that, but going back to Dr. Morley's and Dr. Carter's response about class size, had that petition in May been given to us in May, that didn't change. So the problem that they had then could have been worked out back in June, July, right? Because obviously you guys didn't pick up on it, and they picked up on it. So 2 sets of eyes looking at it shouldn't hurt, should it?
No, I think you're right. Now, there's another component, because up until last week, we were under the impression that the state had the ability to impose its will, and irrespective of what we may have decided about class size. And I'm not sure the state has the ability even, to hear an appeal in this process, but based on what my lawyers were telling me, that we had been engaging in petitions and contracts that basically in many ways we had little or no influence over controlling once the board voted to approve them. That class size then would be something that would be dictated by the petitioner and the state, and not the DeKalb County School District. But we would have to write the check if in fact class sizes grew. Am I right? Am I stating that right? That was an issue being addressed last week in DeKalb.
In view of time, what I'm hearing, and correct me if I'm wrong, what I'm hearing is that the board is desirous of the superintendent taking the petition back to the petitioners to ensure that when it's brought back, the board can approve it collectively and unanimously for the common good of the boys and girls that the petitioners are serving. So if we do that, can I get a motion to table it until moved by Dr. Carter, second by Dr. Marley?
Table it to when?
Is there any discussion? Table it until at least no longer than next month?
No later than October. If
No
the
later.
No later, 'cause they
superintendent
have
can
some
resolve it
time to
sooner,
do
it.
then we
Right.
could have a call meeting.
Right.
Is there any discussion?
Only, Mr. Chair, if whatever your questions are, please get them to us as quickly by Friday, no later than Friday of this week, so that Ms. Copeland and her staff can address the issues and then engage the petitioners so that we can resolve whatever outstanding issues, concerns there might be.
Is there any discussion? Hearing none, all in favor, let me know by show of hands. Count, help me
This
count.
is table, right?
It's just the table.
1, 2, 3.
Okay. Was it 5, 4, 6, 6, 3? Okay. Okay, well, it passes, 7-3, or 6, or was it 6-3?
Right, she
6-3
needs the
to
rec- she needs the
7-2.
record.
Okay. I call for the vote again.
I'm for getting a solution for it either way. So vote tonight or vote in 2 weeks. That's
All right.